Good afternoon and welcome everyone to another edition of the Waterstone Legal Update. I'm William van Roosmalen, one of the lawyers at Waterstone Insolvency, and joining me is Kelly Cocks, our newly admitted barrister and solicitor of the High Court. So congratulations, Kelly, and welcome to the profession. I'm sure it's going to be good to you.
Oh, great. Thank you so much, Will. Yeah, really excited to finally be admitted and looking forward to starting my legal career here at Waterstone.
Nice. So I thought we would start your first week off as a lawyer by talking about Section 250 of the Companies Act, taking a company out of liquidation. This was a much requested topic, so why don't you kick off and tell us the first steps to getting a company out of liquidation and back into trading? What are the initial requirements?
Okay, great. Thanks, Will. So obviously, as you said, this is under Section 250 of the Companies Act, and that's just when you apply to the court for an order terminating the liquidation, and the court will look to whether this is just and equitable to do. There are a couple of general things that the court will take into consideration when looking to terminate the liquidation, and those are that all the creditors have been paid in full, satisfactory provision has been made for them to be paid in full, or they consent to the termination of the liquidation. The next one is that the liquidator's costs have been paid or secured. The shareholders will be in no worse off position than if the liquidation were to proceed. And then the last one is that the order to terminate the liquidation would be in the public interest. So the court also would take some other things into consideration, such as whether taking that company out of liquidation is conducive to commercial morality. But generally, those first requirements that we mentioned are the starting point as to whether the court will or not.
So I suppose the biggest factors are that the creditors are repaid and the liquidator is paid for his or her time in administering the liquidation and doing the preliminary investigations, etc., and that also that the shareholders are not left off in a worse position than they would be if the liquidation had gone ahead. That takes us, I suppose, to the next part of the application, and the rules say that there are a limited class of people that can apply: the liquidator, the creditors, the shareholders, director, even the registrar of companies, and the company itself does not have the ability to make an application under Section 250. So it cannot apply to bring itself out of liquidation. It's like being in purgatory before it's struck off, kind of like us being in lockdown with no end in sight and not knowing whether or not we're going to be released or just in perpetuity. Do you want to take us through the next procedural step in applying to take the company out of liquidation?
Sure. Just before we move on to that next step, you mentioned that the company actually can't take or apply to take itself out of liquidation. And there is an exception to that rule. The court does have an inherent jurisdiction to look at that type of application, although it doesn't fall under Section 250 of the Companies Act. But then for the next step, we've got the effect of a termination order. And obviously what this means is that the company ceases to be in liquidation, and this is either from the date of the order, or should there be another date specified. The liquidator's functions don't come to an end immediately, though. There are some things that need to happen. There's a handover period where the liquidator obviously hands the company back to the board. So yeah, that's step 3. I'm not sure if you'd like to take us through the rest of the process.
Sure. So the The application is brought by way of what's called an interlocutory order. So that's where an application for the liquidation has already been made, and then a interlocutory or in-between application is made to terminate it. So the word interlocutory just means in between. It's a step that's taken in between one part of a court process and another part. So you bring an application with the High Court, your order is accepted or declined, and then what will happen is that the court will give you a sealed order. You send that to the company registrar. They will take it out of liquidation, and then, as you alluded to earlier, there will be a handover period from the liquidator passing back the company into the control of the board. Some other things to note are that the application has got to be sent to the company's office within 10 days of the order being made, and there's penalties for failing to comply with that requirement. So I suppose it's for continuity's sake that the application is actually put into effect. I'm not sure what the exact rationale is for attaching the penalties, but that's something that's been obviously legislated for. So once the order is made, you have to follow through with it, basically. You can't leave the company in purgatory after it's already been in purgatory. So it's got to go somewhere. It's got to be dealt with one way or the other. It's not going to be removed. It's not going to be in liquidation. So it has to be placed back on the register. I think that's most of what needs to be covered in terms of the practical steps. If there are any questions from the audience, feel free to leave a comment below. You can send us an email, waterstone.co.nz. But otherwise, thanks for joining us, and see you guys next time.
Great. Thanks for watching, guys.
Cheers.